Hello, good morning, everybody. Welcome as always. We've got a select group today. I think 38 people have booked, slightly lower than normal because I've had problems with my transferring from one computer system to another, so apologies for that. I'm now going to hand over to Michael Cover, who will introduce and moderate the, well, I'm not sure if he'll be able to moderate the speakers. He will do his best.
Okay. Well, thank you, Dave. Good morning, folks. My name is Michael Cover. It's my pleasure to introduce Sarah Grenfell on the left on your screen, who's a partner in the Infrastructure, Construction, Energy Department on dispute resolution, mostly, I guess, in Cameron, McKenna, Nabarro, Oswang, as they now are. And I think I detect from looking at you, doing a bit of research, Sarah, that you might have a sort of Australian origin, possibly.
I'm caught. Yes, I am. I am indeed Australian.
That's right. And then on the right is Sarah Mather, who's a senior associate in the same group. So we're going to try and run this as a conversation, folks. If you'd like to put questions or points on the chat thing or on the sidebar, then please go ahead and we'll try and pick those up as we go along. The Sarahs have got to leave at 10 o'clock, but that's fine. We'll leave the session open for 15 or 20 minutes for people to chat. So, Sarah G, if I may call you that, do you want to maybe kick off? I mean, I think what we're talking about is really how does ADR in particular, in this case, mediation work? You know, how is it for you? I'd be interested to know how much you use it, how you go about selecting people. And I said in an email earlier this morning, you know, that there's the kind of what did the Romans do for us question from Monty Python, which is essentially, you know, I suppose, you know, what's in it for us, all of us, you know, what's the point of all this? So over to you for a little bit.
Yeah, hi everyone. It's great to be talking about this sort of issue, and very happy to have questions put to either of us about how we approach mediation. But I will kick off with Michael's questions, which I think are really good ones. I mean, I am very pro alternative dispute resolution, pro mediation, because I think at the end of the day, what you want is for you know, for my client to get the best outcome in a matter, and that may involve mediation. It may involve a different form of ADR. And I think that the thing that I often say to clients, and I don't have the stats to hand, but I think the ACEDA publishes periodically the percentage of cases that go to mediation that are successful in resolving on the day, or resolving or settling within a specified period of time after the mediation. And I was really surprised when I saw those figures for the first time. I was surprised at how successful mediation is. And I think because of that, I'm always mindful about whether the case that I'm advising or acting on is one that is suitable for mediation. And a lot of the time that's a question that the client needs to be taking on themselves and thinking about. I think that there are cases that are much more difficult to mediate, and I've had experiences that are positive, and also where I think there's room for improvement. And so maybe I'll give you a flavour of what those are. I think in particular, when you've got a very complex dispute with lots of issues and facts that the decision maker needs to bear in mind, and we've got lots of expert evidence, it can be challenging in my view to run something like that as a mediation, because the question is, how do you simplify it sufficiently to not turn it into a mini arbitration where the parties are effectively running it you know, at reduced cost, but trying to get all the points on the table. And I think those are the scenarios where I've really struggled to persuade clients that it might be suitable for mediation, because they tend to want the decision maker to be apprised of all of the facts. And I think mediation is maybe not always the best forum for that. But where I have found it work really well is where each party, even though they may not say this in the room together, each party recognises that it would be far better not to be fighting and actually to be resolving things. And very few of our clients are really, in the business of disputes. I think that big EPC contractors probably recognize that they will often have disputes that come along, and so they take a very, I think, business-minded view about them. But many other parties will just see disputes as a massive distraction to business as usual. And I think on that basis are often open to resolving things early on, and therefore open to mediation.
And then, so I was just going to just really sort of just pick that up and say, well, what do you think, in your experience, what's the best way of getting to mediation? Do you have a tiered dispute resolution clause? Is it best to have an ad hoc referral? Parties decide, well, let's try and mediate. And what's your feeling about government and regulatory pressure? Sort of mandatory mediation, for example.
Yeah, I mean, I've never really found that parties, if the matter is not going to settle at mediation, or the parties are really not open to even commercial negotiations, I don't think that a tiered dispute resolution clause that mandates that you must have a commercial settlement or a mediation, or the requirements from the court that you do that, I don't actually think that is either needed or necessarily lends to more matters going to mediation and settling. I think that if parties feel like they want to have their day in court or their day in arbitration, then they end up just going through the process without really engaging properly in the mediation. But I think the positive side of that is that I've never had an issue with arranging a mediation or persuading a party to agree to mediation if it's not provided for in the dispute resolution clause. The party, and often parties will be asking us about it as well. We know about mediation. What do you think? Is now the time for it? And we'll always be having a conversation with them about that. So I don't think you need it in a dispute resolution clause, but I think you should always be offering it to your client and telling them the pros and cons, and that's definitely what we do.
Okay. Any other thoughts, Sarah M?
It's quite strange. So I used to do. I've lived and practiced in Dubai, so I used to do like arbitration day in, day out. And actually, when I lived and practiced there, mediation was actually quite a rare thing. It wouldn't be prescribed for in any contracts. And actually, now I've come back to the UK and I'm doing quite a lot of domestic work, court work. Mediation is just part of the course, and it's a lot more common, and it's a lot easier to get buy-in from people. And also, on issues particularly like we're dealing with, I'm sure everyone is, like loads of like cladding claims, defects, all the rest of it. And so a lot of confidentiality is a massive concern because they don't want this to be publicised, and they don't want that to be in the public domain. So actually more and more people are willing to go to mediation on those types of matters. So I think in certain jurisdictions it's not as common as it is here.
Yeah, and then what about I tend to think that we have to look at all, it's a rather a wordy thing, non-court based dispute resolution as a kind of whole. How do you think the effectiveness of mediation compares with adjudication and arbitration, and how have you seen any of these techniques being sort of mixed together one after the other?
Yeah, I think they all have their role to play, and it depends upon the parties and the sector that they are in. So I very much see in the sort of energy dispute side of things that where I represent clients, that the dispute resolution clauses tend to be a bit more standard, in the sense that they may have they may be multi-tiered, but if they're multi-tiered, it's probably a commercial negotiation, perhaps mediation, and then through to arbitration. Obviously, in international projects or construction projects or construction engineering projects, the dispute resolution clauses are much longer, many different stages, and actually can be quite onerous for one of the parties. Whatever party had less power in negotiating that clause, and so I think it's interesting to see how that works in practice, and I think there's a place for trying out whatever works for the parties that are in dispute. And so if I give you an example of that, I had a client recently who had upstream claims and downstream claims. It's a big international project. And
actually, do you just want to mention what upstream and downstream is, just so we all know?
Yeah, of course.
Sorry.
Of course, I should do that. No, so on construction disputes, if you've got the owner on the project,
The employer,
and then you'll usually have an owner or employer, and then you'll often have a main contractor, who is often referred to as the EPC or engineering, procurement and construction contractor, and then that contractor is responsible for engaging various subcontractors. That's an EPC contract. There are different ways of structuring big projects. But what we will often see, which can make these sorts of projects quite complicated, is that the main contractor will have disputes with the employer or owner, and so that's the upstream claim. And they will also have disputes with their subcontractors, and those are the downstream claims.
Okay, cool.
And there are actually real complexities, I think, in trying to settle all of the disputes on a project of that type, often because there will be similar issues in the upstream and downstream claim. And it's often the case that the main contractor cannot join all parties to the disputes to the same arbitration. And so they have to decide how they're going to run it strategically to come out of that as best as possible. But it obviously presents risks, and you have to balance those risks and have a developed strategy. So I think on the project that I was talking about, I think the complexity was that the client had these upstream claims, and there were issues and disputes, and they're trying to settle those through a multiple tier arbitration clause, eventual arbitration, and it was asymmetrical. It was very unfair, in my view, to the contractor and very favourable to the owner. And then they had lots of downstream claims that were arbitration, and there was no requirement for mediation. And so there really was a need to take a holistic view and decide what type of dispute resolution would work best for the different types of disputes. And I think actually the client was very open to different ways of approaching the disputes. And for one of them, for a downstream claim, we went to mediation. It wasn't successful on the day. The mediation was done virtually because it was during COVID. And I have to say, we can explore that a bit further, but I think virtual mediations, in my experience, are not as effective as in-person mediations. But it did settle eventually, and that's because I think the parties just recognised that it wasn't ideal to be going to arbitration, and so I think that worked well. But equally, I've had many matters where the parties will have a commercial negotiation, the issues don't resolve, they think about mediation, they decide against it, they go to arbitration, and then through the process of running the arbitration, they will continue to engage in without prejudice discussions and seek to resolve things, and sometimes do that before the hearing takes place. And actually, it's quite I think it's quite common for disputes to not make it all the way to the hearing and to be settled beforehand.
Okay, and then so we've decided we're going to go to some form of ADR, perhaps mediation. Who do you see as the gatekeepers? Is it still the outside, the outside lawyers, or did corporate, general counsel get more involved, or insurers, or whoever? Who has the kind of shout on the individual, the kind of person that you're looking for?
So who decides who the mediator will be, essentially?
Yeah.
So I mean, I guess I've been fortunate so far that clients have very much wanted our input on that, and so it's been up to us to make recommendations.
Yeah.
And the process that I take, and many colleagues do the same, I'm sure that some do it differently, is that I'll be basing that on mediators that I've worked with before.
Yeah.
But we also have a very big network in CMS, and so emails will often go around asking about these mediators that might be proposed by the other side. What do you think about them? What's your experience? And then there'll be a conversation about the characteristics that you're looking for in that mediator. And then we usually propose a name or a couple of names to the client, and then talk them through those mediators and why they've been proposed. And I think there's obviously something less riding on the selection of mediators than arbitrators, because the decision is not binding. So, and the mediator doesn't make a decision unless you go down that path. So it's more about talking to them about the process and how things can resolve, and helping them to understand what the mediation is going to look like.
Okay. What are the kind of things that irritate you as users about mediators? I mean, people taking on too much might be one suggestion. I just wondered if there's anything else that is a bit of a no-no for you.
I think that I've probably had experiences where the mediators have been friendly, helpful, but quite passive in their approach.
Yeah.
And actually, and I wouldn't say, I'm not saying this because I think that the other side needs to be shouted at, but I do think a mediator needs to, be selected because of their experience. And we had someone recently who was a very good barrister who does construction work, and they came into the matter, and I think that their experience will have some weight with my client and the party on the other side. And so what you really want them to do is to warn the client about the risks of going to arbitration or progressing the dispute formally, and to do the same for the other side, and to really push the parties a bit more. Yeah. And I think also to read the room. I mean, sometimes I think it's very helpful to actually have the parties together, or to think more creatively about, do we need to take this person from this client and this person from this party and get them together in a room, and maybe that will break down what's happening here, which is the parties not engaging. And sometimes I don't see that. Sometimes I see a bit more of a toing and froing between different rooms, and feeling like you're not getting anywhere. And that can be frustrating. But actually, I've had disputes like that, or mediations that have ultimately settled, even if not on the day. So sometimes I think it can be because the parties aren't ready for it and they need a bit of time to think.
Yeah, that's right. And yeah, any further thoughts, Sarah M?
Now that we've been given an open floor to list our complaints about mediators.
I don't know. I don't want to name and shame anybody, but
definitely don't.
Yeah.
Well, particularly since it's being recorded, we'll be in trouble with the BBC, and the broadcast regulator. Yeah, come on.
There is kind of a select few of very famous mediators that we tend to go to, and it depends on what you want. Clients particularly like ex-judges who have become mediators because they have gravitas, particularly as well if you might want like a non-binding opinion or something like that. Yeah. There's also there is quite a famous, well-known mediator who's American, who has a tenancy at Chambers in London, and he takes a very kind of direct approach. So he is a bit of a headbanger, and he does do that sort of, he's very directive, and that's at one end of the spectrum. And then you might have, as Sarah said, a more passive approach. It would be great to find someone who is somewhere in between. And so that's kind of.
I mean, I have certainly had experience with it. I think there's so many good mediators out there. But one thing I do see, which is, it's the same with arbitrators, it's the same with, it's an issue in our profession, is that people feel comfortable with using the same people. Yeah. And you seem to have, I mean, I often see emails going around asking about the same kind of short list of mediators. Yeah. And I think that we've got a much wider and more diverse legal profession. And there must be many different people who could be put forward for mediation and considered. But it goes back to that old issue with the way that humans work, I think, which is you stick with what's safe. And if someone recommends somebody and says, I've used them and they were good, then that gives you some comfort in engaging that person or recommending them to your client. And often that can mean that that's to the exclusion of new blood, so to speak.
Yeah.
Yeah, I was in Vienna last week at the Dispute Resolution Board Foundation Central and Eastern European Conference, and fortunately there were only about 2 or 3 of us old guys there, and there were very strong signs of a much younger and much more diverse group coming through as dispute board members and getting appointments, getting onto the FIDIC president's list and that kind of thing. So I thought that was really quite encouraging. What about specialists?
Michael?
Yeah, yes, Dave.
On this point, Can I just chip in?
Yeah, of course.
A solicitor in a semi-private meeting said that if he thought that his clients had a good case, they'd always like to go for a lawyer mediator. Whereas if they thought they had a poor legal case, they'd like to go for somebody who wasn't legally qualified. I'm wondering if the two Sarahs would like to comment on that.
Yeah, it's an interesting approach. I mean, I think the comparison would be where you hear about people looking for arbitrators that are very black letter. If you think that you're strong on the terms of the contract, or you want someone who takes more of a fairness-based approach, if you think that you're not great on the terms of the contract. I mean, I think at first I'd say I do think it's a bit hard to know how a person is going to decide a case, and just because someone is not a lawyer doesn't mean that they don't have the ability to read through the parties' different provisions and have a look at the issues and reach a view that may not be favourable to you, even though they don't have a legal background. But it's one approach to take. I feel as though if there's any legal issue that's involved, and you really want to have a bit more certainty about someone, properly engaging with the issues, then it can be better to have a lawyer on it. But these are all points of strategy. I think the bigger challenge actually is where there are combined issues of where expertise is needed, technical expertise, or the sort of expertise you'd have from an expert witness, and there are issues of law, and you may feel that the person who is going to be the mediator doesn't hold all of that experience themselves, and what you do in those circumstances. I think that can probably present a bit more of a challenge.
And then what about, obviously, I think certainly you, Sarah G, are involved in what sort of energy disputes, or what sort of energy, what do you see the future of energy, what we might call energy transition disputes? We might touch on HS2 in a moment, but let's stick with energy for the moment.
Yeah, I think that I mean we could spend a couple of hours on this, Michael. Yeah. I think that there's going to be a changing nature of the sorts of disputes that we'll see coming through. I mean, typically the disputes that I've worked on have been oil and gas, and obviously we're seeing things change quite a bit and move more into power or renewables disputes. So it's an interesting time. I do feel like at the moment, I mean, we tend to be a bit behind our transactional colleagues who really are more at the cutting edge of what is happening, and then disputes tend to take place a bit after that. But I think at the end of the day, if we're talking about how disputes arising in the energy sector are resolved, I think that parties are very open to mediation, and also expert determination can be something that can be quite effective. And often you'll have an expert determination clause in some contracts, some energy contracts, but that also brings with it its own risks. Yeah, but I think the thing about, excuse me, about energy clients is you obviously have the big energy companies that are very experienced. I mean, if they're oil and gas majors, they will have usually a disputes team that's been running disputes for decades. I think now what I'm starting to see a bit is some newer entrants into the market, and I'm advising on an offshore wind project in Asia at the moment, where I've got a client who's very aware of the fact that they are moving into an area that they're unfamiliar with, and very keen to avoid disputes. And so what they've asked us to do is to come on board and carry out a risk assessment based on the contract, and help prepare them for what they see as being the risks of disputes arising. But they're also giving thought to the relationship with the employer and how they might manage these sorts of risks going forward, and different types of dispute resolution. So I am seeing now, I think, parties wanting to take steps and prepare earlier on in the project phase to avoid disputes. And I haven't tended to see that so much in the past. And I think that's because the clients that we represent have been working in those sectors for a very long period of time, so they know what they're facing. I think that's what is starting to change a bit.
Yeah, I mean, we might just spend a minute or two talking about dispute avoidance and adjudication boards, which I sometimes call conflict avoidance boards. And certainly in my experience, you have the ability there to use all the techniques that we've been taught, all the ADR techniques that we've been talking about. A lot of the time, of course, it's about the people, isn't it? You know, it's not necessarily about unforeseen utilities under Princes Street in Edinburgh, as happened with the Edinburgh tram. You know, it was peripherally involved in that. Was all the people hated each other, and that was what the trouble was. And I mean, what's your experience of dispute avoidance and adjudication boards and their effectiveness? Very often they're supposed to be standing boards, but they're not, you know. But there's an interesting mix of mediation and adjudication techniques and all sorts of stuff, isn't there? I just wondered what your experience of that is.
Yeah, I might pass it over to Sarah. She's a lot of experience on adjudication.
Okay.
And then I'm going to say something about in international clients' perspective of adjudication. I was a bit surprised by the process recently, but yeah.
Okay.
No, I've done quite a bit of adjudication, particularly recently. I personally don't have any experience of dispute adjudication boards. I mean, I think they got quite a bad rep, didn't they, in the Channel Tunnel litigation or the ongoing problems there. I think they're very expensive. I'm not sure they're the best thing, if I'm completely honest, but I mean, again, I have no personal experience of them. I've just read quite a lot about them. I do a lot of adjudication now, and it is interesting how you can use adjudication strategically. So if you have a project, a huge project that's in distress, how you can use adjudication particularly on a discrete issue to apply pressure, and if you win on a discrete issue, on a discrete matter, you can then use that to then negotiate a global settlement. So yes, I suppose, and if you can use a dispute adjudication boards in the same way, which you can, I can see the kind of the utility of that and how useful it could be. Of course, it's not nice to be on the receiving end. An adjudication where, on a discrete issue or several discrete issues, and then you're put under pressure. But no, I can see the benefits of them. But I mean, they on large scale projects, I mean, they are very expensive.
Yes, exactly. Sorry, you were going to say something about adjudication. Maybe this kind of rough and, it's rough justice in a way, isn't it? And rough and ready and very fast and very difficult to undo.
I got a successful adjudication decision yesterday, so I'm at the moment.
Oh, well done. Well, you're
pro adjudication.
And today I'm pro adjudication, but yeah.
Yeah, and of course, adjudication. Some of the disputes are absolutely enormous, aren't they? I mean, I think you were going to say something about that, Sarah G.
Yeah, I mean, I was
the surprise of an international client about maybe the rough and ready nature of it.
Yeah, well, so they don't. I think they haven't had a lot of projects that have been in the UK. They do projects mostly in Asia or the Middle East, and have had projects more recently in the UK, and were a bit shocked, aghast at the adjudication process. They'd never heard of it before. So our firm wasn't involved in the contract that was being the transactional side of things, and then I think they were exposed to some strategic adjudications being run, and were just really surprised at the process and felt that it was frustrating. I think because it wasn't a final decision in the sense that you can then go to arbitration, and they also found the rough and ready justice to be a bit frustrating. But I'm sure if they had won the adjudications that have been run, then they may have felt differently about it. I think picking up on your point, Michael, about whether these sorts of things work, I think the difficulty is that it only works if parties want it to work, if they have buy-in, and if they really want to avoid a massive, long-running arbitration that ties up their people and exposes them to arbitration litigation risk. Then, or if they've had that experience before and it's not been a great one, even if they've been successful, I think you've got more of a chance of them engaging in the process early on, making sure the dispute resolution board is set up properly, making sure you get the right people on it, and making sure that you engage. But far too often I see scenarios where these clauses are entered into and then they're not really properly followed. And then the parties start to become a dispute arises, the parties' positions become entrenched. And I think in those circumstances, it's quite difficult to resolve by ADR if parties are intent on then running through the arbitration.
Have you had any experience in civil law jurisdictions of settlement meetings? In other words, the arbitrator or arbitrators engaging in settlement discussions, obviously not having confidential meetings. I just wondered whether you'd had any experience of that, and then maybe we'll touch on costs after that. Yeah.
Yeah, I mean, settlement meetings in civil jurisdictions, I haven't had experience of that. Apart from Sarah and I actually were co-counsel on a civil court matter that was run in France recently, and it was certainly it was very interesting to see the French court process compared to the English court process.
Interesting, yeah.
That's the word I'll be using today. It was, yeah. And I think our client is English, and really, I mean, it's just very difficult to describe to a client. I think the lack of everything just felt like it was quite uncertain by way of process. But my recollection is that there was, I don't think there was a requirement to have a settlement in the way that there is. So you didn't have the similar focus as you do here on having mediations, unless I've misunderstood what happened, but it was in the French administrative courts and we weren't required to have any settlement meetings, and everything was largely done on the papers. So that process was interesting to do by comparison, but I think it also led to a bit of a lack of engagement between all of the parties. And as a result, we never ended up having a mediation, even though it was proposed to the different parties that they were happier to let the court process run. But other than that, I haven't had experience. But if others on the call have, I'm very happy to hear from people.
Well, my colleague Stephen Bate Martin's got a question about reality testing. Can we bring Stephen in?
Thanks, Michael. Sarah,
good morning.
Good morning. I have a question which relates to risk analysis, and I wonder to what extent you find that helpful in the reality testing part of the process. My experience is that claimants often don't price in properly the possibility of losing. They assume if they've got a good case, they're going to win it. And defendants often don't price in adequately the consequences of losing. And that can often have the result that the parties can be closer to a settlement or possible settlement than it might appear.
Yeah, I think that's a very good observation. We sometimes by clients get asked to do a quite detailed cost analysis, looking at best case scenario, worst case scenario, and something in between. And that obviously must involve what the consequences are from a cost perspective. And I think that's so important, because succeeding but actually having to pay some of your costs and may not end up being the best scenario. And the alternative to that is losing and having to pay your own costs and a lot of costs to the other party can have quite a dramatic impact on where a party sees its position. So I think it's really important to do that, and I think it's important to do that before you have a mediation, so that your client has really thought carefully about what is an appropriate settlement range. But I actually think there's something on top of cost that you should be looking at, and it's the time that is required from a client, and the stress that parties are put under. And I had an arbitration recently where it ended up resolving through settlement negotiations. It was for, I think the sums, the consequences of the dispute were close to $1 billion.
Oh, good heavens.
And at the end of the day, one of the witnesses, who was going to be a witness of fact, who was a senior person in the organisation, had said to me that she was, the whole process was just incredibly stressful for her because of the work that she had to do and the witness statement she had to prepare, and recognizing the stress that she would be under being a witness. And I think that there's a lot of people who maybe don't think about all of the factors and consequences of running through to the final dispute. And would it be better to suffer a little bit of pain now, for both parties to be maybe a little bit unhappy, but to make it all go away? And I think it's a really good point, Stephen, because I think sometimes that is not thought about properly. by clients. We certainly try to get them to do that, and the more sophisticated clients we have will be asking for that and require that as a matter of course in order to dictate what they do in the course of the mediation, arbitration, the dispute.
Well, that picks up a point that Dave made, I think, in an email a bit earlier today about advising the clients, you know, on what the likely outcomes might be and what percentage of chance they might have. Sorry, Stephen, did you have a follow-up point?
Well, I think it's only this that that is obviously, not obviously, but it is so true. And one of the very interesting things I think for mediators to know how the decision-making process unfolds in the rooms when the mediators are not there, when the mediator's not there. And it's so much, as we know of this process, is as it were behind the curtain. You can't see things that you'd probably like to know, and we can't see things that we'd like to know. And it always strikes me as something of great interest, how those discussions go privately. And I suppose the challenge is, isn't it, to be able to hold in one's mind all these competing considerations and then strike a balance for the client that delivers the appropriate outcome.
Yeah. I think if we're talking about, I mean, yes, I think if you're coming from the mediator's perspective, what I would like mediators to do is sometimes more than what I see them do, and maybe it's because there's a feeling that you don't have this information at your fingertips, you don't have the precise figures, but it would be to remind parties in more detail and stressing this more, that there are real risks in any formal dispute. I don't think any competent lawyer should be saying you will win this, absolutely guaranteed. You can always have a tribunal that goes rogue and you end up getting a decision which is not what you think is the correct decision. So they always should be factoring that in, and then factoring in the cost consequences of that. And I think emphasizing that to clients and having it come from a different voice to their lawyers can often be a helpful thing to be stressing in a mediation. Whether or not they listen to you is a different thing.
Yeah, I think I once went to Harvard for a couple of days, and we were addressed by one of the academics there. I think it got to the advanced age of 50 or 60 or something. He decided to go, and this was quite a few years, he decided to go to the Middle East to see if he could sort out the Middle East dispute. And what he found was, having lived with, you know, both the Palestinians and the Israelis, actually, that to an extent, the people, as it were, in the opposite rooms, some of them had more in common with each other than they did with the people in their own room. And that's, I guess, part of what you're talking about, Stephen, you know, that, you know, finding out, you know, what's going on within the room, because not everybody's interests in one of the rooms, and there may be more than two, are necessarily aligned. There may be a, you know, disparity of interest between the lawyers and the clients, or basically somebody's job's on the line because there's been a bit of an error, which probably wasn't their fault, but they might get the blame, you know, that kind of stuff. So a lot of it comes down to people.
And I think what it opens the way towards is the possibility, and it's never struck me as really an available option, but I think it might well be now, is some form of joint session with a mediator where you're looking at risk, where you play around with the percentages, because you don't have to disclose, you know, what your, you know, how strong you think your case is, other than you may well say, well, you think we're going to win, or whatever, however you want to put it. But the mediator is in a position to play around, as it were, with risk in sessions with both sides, which I think could be of use.
Yeah, and I think parties may not be opposed to, you know, providing the mediator with their legal costs, so that the mediator can then take that from each side and then look at the sum in dispute. And as you say, play around with things to say, you know, worst case scenario, you could end up in a position where you're out of pocket for X amount. And that may not be, you may think that that's not going to be the outcome, but that is one of the risks that you should be holding in your head when you're thinking about what's an appropriate settlement range. I do think that is a good approach, but at the end of the day, it requires clients to to not be overly optimistic about their prospects, and to recognise that that's not about the merits of their case. That's just a simple risk issue.
Yeah, exactly. Now, maybe that takes us into costs. I mean, let's maybe split this down into two. I mean, maybe bring in Sarah M here. What do you think about the costs of mediation and mediators? I suppose there's two parts there. I mean, my own thought is sometimes mediation is too cheap and sometimes it's too expensive. Sarah M, what do you think about that?
I've never really done a mediation where there hasn't been court proceedings on foot or an arbitration. So when you're comparing the costs with that, actually the costs of mediation are quite low, really. I mean, you're talking about, you prepare your mediation statements, a pre-meeting with the mediator, your actual mediation session itself tends to last one day. What can be expensive and is the ongoing, the follow-up. So whether you choose to use the mediator afterwards to continue discussions and things like that, or whether the parties do it themselves. But I actually don't think mediation is that expensive, particularly in comparison to litigation. And actually it's in every mediation statement that I've ever kind of prepared, you always kind of disclose your legal costs, as Sarah said, anyway, and that can then apply pressure, and you can use that to your advantage, or maybe not if you incurred disproportionate costs. It depends what side you're on. But no, I mean, I don't think the costs are significant at all.
Okay, but I mean the way that costs work in international arbitration and indeed in litigation. I did a cost award in one of my arbitrations just before Christmas, and head of international arbitration, a big firm, was nudging $1,200 an hour, I think. So, sometimes the experts make the lawyers look quite cheap, don't they? So, I mean, do you tend to bill your clients as you go along, or on a monthly basis? I guess that's the kind of pretty standard practice now.
It's always so. I did actually a multi-party mediation last April, and there were 6 parties involved, and we were the claimants, and our costs were, this was for like a big distribution centre that was defective, and our costs were about, I don't know, $1 million, and this was like a year and a half in, and the guarantors' costs, who were on the periphery of the dispute, $5 million. And they weren't even we were the claimants, so we were doing all the work. So it's very, very interesting when you get to the mediation phase. What are you arguing about, the dispute or the cost level? And the guarantor really wanted something for the legal spend that they'd incurred, and that's when they got very unreasonable. So actually, when you should always put the legal costs in context. It's quite interesting.
I would say, sorry, Michael, I was just going to say I would say the same, and I think it is as a result of the comparison between whatever formal proceedings are either threatened or running. By comparison, I think mediation always seems very cost effective. Having said that, I have had clients who, in the context of having to spend more than 1.5, maybe 2 million on an arbitration, might balk at spending the money on a mediation because they see it as an additional expense. And it doesn't matter, how many times you might say to them, yes, but you could avoid, the formal dispute. If they think that they're going to end up in a formal dispute anyway, they just see it as an additional cost. And so occasionally I have had clients who have not wanted to go down that path because they just feel like it won't achieve anything. And I think the statistics would say otherwise, but you can't compel your own client to go to mediation.
Yeah, and it's funny you should say that, because often I'm sure there'll be other mediators on the call who will have had experience where the mediator's fees agree, but then one party kicks off about the cost of the sandwiches or the venue, So you never know quite where people are coming from on this additional expense. I was just going to ask you a final question about how well prepared parties are. Because as I suggested to you earlier this morning, sometimes the answer to that one is not terribly well. In other words, I suppose the key question is, do two parties, this comes back to Stephen's point about, do they sometimes not have any idea where they might have, what they might have to do, how far they might have to stretch in order to settle?
I mean, I think it's also involves how prepared is the mediator, and this maybe this comes back to your previous question about being overly stretched. If the mediator is overly stretched on appointments, do they have sufficient time to really read into the matter and engage? I think that generally the mediations I've been on, I mean, we always try to be proportionate in the cost that you're spending on things, but because you will be developing the case in the formal dispute, then you usually have a pretty good idea of how you want to put things across, and it's more a matter of how to do that more simply in the mediation. So I don't see that really as being an issue, but I think where a mediation doesn't sometimes work is where you have a conversation or a presentation to the other side and they don't engage, the parties don't engage with the points that are being made. And I had a mediation, the last one I did, where each party, gave its opening position and then they were broken out into different rooms. And I just thought that there was a real lost opportunity to try to engage a little bit. I mean, you can only take that so far because you don't want lawyers sitting in a room arguing with each other, but a little bit of engagement on the respective positions, and there wasn't really any of that. And then for the rest of mediation, the parties stood apart. And so I think that there was an ability to test the other side and to see if they were sufficiently prepared or not. Okay. So that can be frustrating. Now, Michael, I can see that Roger's got his hand up.
I was going to open it up. So Roger's got his virtual hand up. So Martin, you want to bring Roger in? The floor is yours, Roger.
Thank you, Sarah. It's very, very, very interesting. And we've got on to the topic of preparation, and I would say that it's impossible to underestimate the importance of preparation, both by the participants and the mediator. I think that one of the features of some mediators perhaps doing too many mediations is that it's not possible for them to prepare in the same way. But if a full preparation 1 or 2 weeks in advance, engaging with the participants and fully understanding where they're all coming from, and also going into a previous point that Stephen raised about risk assessment, I think that all goes to point towards getting people in the right mindset, and the right mindset is key. And I think that sometimes that level of preparation isn't fully possible if people are doing too many, but really is absolutely key.
Yeah, I think you're entirely right on that. I think that the wasted opportunity if you end up having someone as mediator who's not really engaging with the issues because they're not up to speed, and also I think it deprives you of the ability to really hone in on something that someone is saying and to call them up on it, even if it's in a breakout room, and to say, you're pushing this angle. In my experience, I think that you have a real risk there. So you might want to think about that, and you might want to think about the risks of running this all the way through. And I will be speaking to the other side about the risks that I've identified in their case. I don't think you can do that if you have not really read in. I also think engagement with the parties beforehand is really helpful, but I always find those calls a week or two out to be really effective. You want to get to know the mediator a little bit and to feel as though you've had a chance to have a conversation before you're in the meeting on the day.
Okay, Martin, can we bring in, thank you, Roger. Would it be okay if we move to Hugh Elder, who's got his virtual hand up?
Thank you very much.
Go ahead, Hugh.
Just a question really on the non-legal costs of continuing with litigation or arbitration. And Michael, thinking about your experience of Harvard, I wonder if anyone has ever attempted to produce a formula for the cost of a business of having its executives engaging in litigation or arbitration. I know it would be incredibly difficult because every business is differently run, and the different issues. But I wonder if anyone's ever attempted to put a formula for that.
Well, either of the Sarahs, have you been
I
when you've been
think,
advising your clients? Has anybody ever come up with anything?
yeah, I seem to remember, and I don't have, I can't remember this well enough to go into any more detail than what I'm about to say, but I seem to remember us having a presentation from someone a number of years ago at CMS who was, who kind of had taken this approach that they wanted to they had a mathematical background, and they were looking at how to formulate the total costs and risks associated with a dispute, and we had them come and speak to us in the context of, you know, like a training day or an away day. And I remember thinking that it was very interesting to hear that approach, but also I think it's very difficult to actually to do that in a way that is, you know, getting down into the degree of granularity that you need, and actual legal cost and you know, the time that would be spent on something for a senior person is one factor, but I don't think it's everything that parties should be taking account of. The client that I talked about before, I think there's a huge amount of personal stress that parties are under in relation to disputes, and I don't think you can necessarily put a number on that. But yeah, I think that there must be people who think about how to do that. But at the end of the day, we're left with our mathematical skills as lawyers, and sometimes they're good and sometimes not so good.
Yeah, it's interesting. This conference I was at last week. A German lawyer called Sebastian Hook. He was talking about the kind of people that you needed in dispute resolution. So this was obviously basically construction related. Talk about engineers, experts, quantities of hours, all these kind of lawyers, all these kind of people. And then he mentioned psychologists, you see. So I think there was everybody in the room went, oh dear. But as I said right at the end, well, actually, this isn't such a silly idea, because you're talking about the individual you were talking about was obviously under immense. So I suppose you've got, I'm not putting this over, you've got two things going on. You've got the stress on the individuals, and then you've got the relationships between all the different people in any dispute, which are hugely important. And so it wasn't, I said it wasn't such a stupid idea after all.
No, I don't. I mean, the relationship point you make, that I think that has been talked about for a long time with clients, but not really. It's more about, is there a relationship that you want to preserve here? So is there an added benefit or bonus or reason for trying to settle without destroying the relationship? But I think that there has been far less focus or discussion about the impact that it has on individuals. And we all hear horror stories. I mean, I was speaking to a colleague about a dispute that he was on many years ago, and essentially one of the witnesses had to had to go on stress leave from their job because of the pressure that they came under giving evidence. And sometimes it can feel as though the evidence that's being given by one person can make or break a case, and that's a lot to be resting on one person's shoulders. So those are certainly things I think that sophisticated parties do take into, or I should just say maybe experienced parties, those who've had a lot of experience with disputes, take into account, I think, when they are thinking about what the best forum is for resolving an issue.
Well, I know one of the Sarahs, I'm going to wrap this up in a couple of minutes. I just wondered if you'd both like to make some final brief observations on my kind of what do the Romans do for us question, which is really, you know, how can we all work together to make this better? In particular, how can, you know, new people, younger people, more diverse people be brought through? I just wondered whether you just, each of you just briefly like to say whatever you like on that.
Well, I mean, you know, we're litigators, but actually more and more, you know, we want to settle disputes for our clients, and you know,
you're resolvers,
yeah, exactly. And then move on. And actually, if you have a happy client, they're going to give you more work.
Correct. Yeah.
It is basically to everyone's benefit that you resolve disputes quickly, as quickly as possible, in the most proportionate manner. And I think, you know, the sooner everybody kind of has buy-in to that process, the better.
Okay. Sarah G.
I think what I'm always looking to achieve is the best outcome for that particular client in the context of the particular dispute and the project or whatever the issue is, and that can mean different things. And so, as Sarah said, I mean, pushing for arbitration is certainly not what our business is. It's about deciding whether the client's going to be happy at the end of the day. So I think that ADR and mediation in particular has always had a really important role to play and will continue to have that sort of role. And I think as far as, trying to widen the number of people or the background of people who are involved in being mediators, I actually think at the end of the day, it's just about a bit more networking perhaps, and it's lawyers having to do that, the lawyers who use mediators as well as people who are new to mediation, and getting your name out there, because I think you've got to test someone, and mediation is actually something where the consequences of testing someone unknown are likely to be far less dramatic than in an arbitration. So we're always open to that, and I think we're always making sure that we've got shortlists that have candidates with a good range of background diversity.
Okay, well, it's 9:56. It remains for me to thank you so much. Had a message from Dr. Mary. I must leave. Thank you so much for an excellent session, Mary. So thank you very much from me and from Dave. So we'll let you go and get on with your, no doubt, very busy days and making clients very happy and resolving things. That's fantastic. Okay.
Well, thanks so much for moderating, Michael. It was a delight to join.
Really enjoyed it. Yeah, it was fantastic seeing it from the user's point of view. It really was. Everybody's sort of applauding and stuff. Jolly good. Okay.
Thank you. Have a good day.
We'd like to drop off and okay. Thank you very much. Right, Dave, over to you.
Thanks very much, Michael. Just two things really to cover. Firstly, the next meeting is going to be on Wednesday, the 3rd of May. So unusually not the 2nd or 3rd Wednesday of that month. So Wednesday, the 3rd of May, I'll send round the flyer as soon as possible. Roger Levitt is going to be a speaker,